Law is not neutral. Its vocabulary is constructed to tilt power toward the state, courts, officers, and institutions. Terms like actus reus, mens rea, and possession embed guilt linguistically. And so does the word legalization, when it reframes a nullified prohibition as state permission. We will trace etymology, show possession's presumption, map mens rea and actus reus, and compare the linguistic trick in cannabis legalization. This is not an abstract word game. These are rhetorical and legal tools that shape outcomes. In Roman law, reus or rea simply meant the party to the matter, the one involved in a case. It was neutral, res =, thing matter, reus =, the person concerned. When English law adopted these terms, meaning shifted. Actus reus came to be read as guilty act, mens rea as guilty mind. But modern doctrine still proclaims innocent until proven guilty. The words used in everyday adjudication, however, presuppose guilt, silently. Terminology shapes thinking. Judges, counsel, and jurors hear guilty act, not alleged act. That rhetorical tilt biases the process before evidence is assessed. Recap: Latin, neutral, English, shifted to guilt. The trap is subtle but consequential. Next, possession, the folk maximal that becomes a legal presumption. Folk maxim: possession is 9/10 of the law. In practice, possession becomes a prima facie presumption of ownership, and of guilt. Possession statutes criminalize neutral states of being. Mere physical relation to an object becomes culpable. Constructive possession doctrines expand liability beyond physical control to proximity and constructive control. Cannabis prosecutions show the effect. Presence alone can trigger charges and conviction, despite weak causal harm. Mens rea originally meant the mind of the accused and neutral. Reframed as guilty mind, mens rea weaponizes inner thought. Intent becomes a field of state control. Actus reus, literally act of the accused, is recast as guilty act. Any observable deed can be framed as criminal, especially when paired with possession and intent. The teaching frame: possession does most of the work. Mens rea and actus reus complete the closure. Together they create a closed system where innocence survives as a legal fiction, not a lived presumption. Constitutional principle: a law repugnant to the Constitution is void. Marbury v. Madison. If prohibition is void ab initio, the correct remedy is nullification, erasure of the bad law. Instead, states declare legalization, reframing the plant as illegal by default and permitted by state grace. The message: you were guilty until we granted permission. Both examples invert a neutral status into illegitimacy through language. Reframing preserves power. People become dependent on state permission for what was previously neutral. The consequence? Language becomes a first weapon of government courts. Subtle, persuasive, and durable. Legal scholarship must expose this weaponization with clarity and refuse linguistic fraud. Remember, actus reus and mens rea aren't guilty by origin. Legalization can be a permission narrative. Both are rhetorical inversions. This lesson taught you what these terms are not. Class dismissed.